one of the things that I've run into, especially with trusts and trustees, is if I don't have a family member that can be a trustee, like that happens a lot. Like I have an only child, or there's nobody else. No, I can't trust the rest of my family to give control of the trust and all of its assets. So, the bank that he was at was kind of one of the only solutions in town that could have an institutional trustee manage the trust for some people. But what other solutions have you run into or found when it comes to the lack of a good identifiable trustee to help manage the trust going forward?
Yeah, usually, like you said, often it's family that is doing that. If they can't find family, then usually it's finding a commercial trustee, and usually that's banks. Having a bank or an institution be the trustee of that. And when I was younger in practice, I thought, family can always work it out.
Yeah, yeah.
and then I had a case where we had 4 kids on one side and 1 kid that they on the other side of the fence. And the 4 thought that the one was manipulating and controlling mom. And we ended up appointing 2 co-guardians of the 4 so they could work together. Well, we had some pretty high drama right before mom died. And one of the 4, which happened to be one of the co-trustees, flipped camps.
Oh.
And so after mom died, we now have 3 with one of the co-trustees, and they have 2 with one of the co-trustees. And so now you got a co-trustee in each camp. And in this case, there was a lot of knickknacks. And the goal was to sell the knickknacks at highest priced value through the course of many years. 3 years, I think we had said 3 years.
Yeah.
And they just could not agree on anything. And I had done the trust, and so I said, look, I can help you if you guys will mediate. If you guys come to a point where you can't reach agreement, I can't represent 2 different sides, and I can't represent one side. And they couldn't reach agreement, so they both hired attorneys. They both fought in court as to who should have priority and who should be dismissed. And eventually the court just said, enough, we're going to appoint a commercial trustee. And ironically, it was actually Tim that was appointed when he was with the bank.
Gotcha.
At that. And he came in, and as a neutral third party, they held a sale, sold it at the highest value within a very short time frame, because that's what the court had ordered, because the family wasn't able to get along. And distributed the asset. So after that case, it just made me think, there are situations where families they have difficulties getting along, or they don't have anyone else. And a commercial trustee in those situations is very highly beneficial to keep that family conflict down.
So that also leads to a question about co-trustees, where my opinion's always been, please don't have a co-trustee. Just have someone that takes the weight of it and makes decisions and moves forward that you can trust. But what's your thought on co-trustees?
Yeah, the longer I've been in practice, the more I lean to where you've just stated, where if they're going to do co-trustees, I really make sure that do they get along, and what's the reason for it?
Yeah.
I've had situations where you have a local child but doesn't have much experience, and you have maybe a child that's in a different state that could handle it a little bit better. And the reality is they will both be calling banks. They'll both be doing different things. And so if they're both going to actually be taking action on the trust and gathering the assets, paying creditors, then I've been okay, as long as both of them are actually going to be taking action and they both will get along. But you're right. You've got to be careful.
Yeah.
With it. It is easier to name one, and then have them talk to everyone, make sure everyone's in agreement, and then they can just move forward.
Yeah. What prevents an attorney from acting as trustee on a trust?
So an attorney can, and actually
I can't. Financial advisors can't. But I've always wondered where you have an estate attorney who really has drafted those documents, understands the wishes of the family, has been integral in all of this stuff, has the ability to potentially be a trustee to help with that liquidation or whatever. Why more of them don't head down that path? I
think for me, as a as a solo practitioner until more recently, where we've now, we're up to 9 or 10, and not all of them are full time. It's a lot of them
Yeah.
part time. Up until then, I really wasn't set up to do that. I set up to do the estate plan to get that in order, but just didn't have wasn't set up.
Yeah.
Skill set to do that.
Yeah.
With Tim being there and with him having that experience and having done that, there was a client that didn't have anyone and has a ton of stuff, and she doesn't have any children, and she's married and he has children, but she's very, very particular about how she wants things to be handled.
Mm-hmm.
And so we've agreed to act as the trustee in that situation.
Yeah.
And to move forward and make sure that her wishes are carried out. And so from our office, we're looking at it more now that we have someone that has experience, number one, doing it, and can move that forward. I'll be honest with you, the other reason is because until we had that, it was cheaper to go with a commercial bank than it was to come with an attorney. Because at the bank, you're paying 100, 150 an hour for them, and attorney, if we were paying 300 an hour, or the individual you mentioned, I think is a little bit more than that. And so a lot of times it just came down to cost too, that they wanted someone that could do it at the best rate.
Yeah.
And as an attorney,
It was harder.
it was harder to do that. So I think that might be another reason.